As Justice Alito said, yesterday's decision from the Supreme Court was legislation, not adjudication. For the Colson Center, I'm John Stonestreet. This is Breakpoint. Yesterday, by a 6-3 vote, the Supreme Court ruled that Title VII of the 1964 Civil Rights Act, which prohibited discrimination in employment on the basis of sex, also includes sexual orientation and gender identity. The decision from Bostock versus Clayton County involved 3 cases. In 2 of them, a social worker and skydiving instructor claimed they were fired for being gay. The 3rd case involved the firing of a funeral home employee who, after being hired as a man, identified and presented as a woman. Now, everyone expected this decision to hinge on whether or not the word sex should be limited to a biological understanding or expanded to include categories of sexual orientation and gender identity. The lawyers for the defense argued that when Congress passed the Civil Rights Act in 1964, they had no sense that the word sex meant anything other than biological categories. Therefore, ruling for the plaintiffs would amount to rewriting the Civil Rights Act, something only Congress can do. Well, Justice Neil Gorsuch, and a bit of rhetorical jujitsu, succeeded in rewriting the law, even while denying doing so. After claiming to agree that homosexuality and transgender status are distinct concepts from sex, he then argued that discrimination based on homosexuality or transgender status necessarily entails discrimination based on sex. Sex, wrote Gorsuch, plays a necessary and undisguisable role in the decision to fire a homosexual or transgender person for traits or actions it would not have questioned in members of a different sex. And that, he wrote, is exactly what Title VII forbids. So in other words, rather than directly saying the word sex and Title VII should include sexual orientation and gender identity, he essentially argued that if employers wouldn't fire a man for sleeping with a woman, they shouldn't be able to fire a woman for sleeping with a woman. Extending that logic, if a woman's allowed to dress like a woman, well, you can't fire a man for dressing like a woman. Now, to be clear, Gorsuch didn't really explain why his logic applied to transgender persons. He assumed something that many gays and lesbians disagree with, that what applies to same-sex attracted people is equally applicable to transgender people. Of course, the T that hitched late to the acronym has long made their living off of others' fights. Consider the Black Trans Lives Matter movement, for example. Gorsuch anticipated the objection that sexual orientation and gender identity were the furthest thing from the drafters' minds. Those who adopted the Civil Rights Act, he wrote, might not have anticipated their work would lead to this particular result. Likely, they weren't thinking about many of the Act's consequences that have become apparent over the years, including its prohibition against discrimination on the basis of motherhood or its ban on the sexual harassment of male employees. But the limits of the drafters' imagination, he wrote, supply no reason to ignore the law's demands. Look, if Gorsuch is right about that, then there is no fixed meaning in the text of any law or statute. As Justice Kavanaugh wrote in a stinging dissent, claiming to uphold the literal meaning of the word, Gorsuch completely savages the ordinary meaning of the word. Justice Alito, in his dissent, took it even further. A more brazen abuse of our authority to interpret statutes, it's hard to recall, he wrote. In fact, Alito's closing words are worth quoting here in full. The authority of this court is limited to saying what the law is. The court itself recognizes this. The place to make a new legislation lies in Congress. When it comes to statutory interpretation, our role is limiting to applying the law's demands as faithfully as we can in the cases that come before us. And then Alito writes, it's easy to utter such words if only the court would live by them. Now, the consequences of yesterday's ruling will be significant. It is, to be clear, a broad ruling masquerading as a narrow one. Justice Gorsuch claims that the decision has no bearing on bathrooms, locker rooms, and other things of that kind, but that's patent nonsense. This is more likely the beginning of a national SOGI law, in which sexual orientation and gender identity is equated with race, and protections are extended and applied to other areas of the Civil Rights Act, including those that govern housing and education. You remember when we were told that Obergefell would have no bearing on religious freedom or any other issues? Look, certain ideas, when imposed, make other ideas possible. sometimes even necessary. And yesterday's decision would have never happened without Obergefell. The decisions of tomorrow, when Title IX and other federal laws are completely reimagined as if biological realities don't exist, they will be made because of yesterday's decision. For Breakpoint, I'm John Stonestreet.